But how do you reconcile the Electoral Commission Elections Act which says no by-election will be held 6 months? We are here after receiving the judgment in the matter of Madam Freda Nambi, the loser in the Kawempe North election, where court has set aside the results and it has said that people should go back into a by-election. We are dissatisfied with the court decision, although we respect it. We believe that it is erroneous, both in law and in fact, and we have strict instructions from both Honorable Nalukoola and the party which sponsored him to appeal this erroneous decision. And if we are comfortable that if we submit this same evidence before the Court of Appeal and it's subjected to a fresh scrutiny as demanded by the law, and they apply themselves to the law and the facts beforehand, they'll have no reason but to set aside this erroneous decision, which we think that it even sets democracy aside for anyone to say that if people come at a polling station amid security, they kick ballot boxes, they tear ballot papers after people have polled, and they otherwise disrupt the counting of the exercise like they did in these 14 polling stations. And an election is overturned on the basis of that. It will set a bad precedent for democracy, that because losing candidates will be doing this, unless court wants to promote this, that if you see that you are losing, you organize goons to come and disrupt the counting of the elections. So we think that it sets a bad precedent, and court had an opportunity to condemn the violence by not rewarding the people who committed the violence with an election victory. So Council Alex will give a deeper analysis of the judgment, and then Council Luganda will also give a deeper, Council Moizu will give a deeper analysis in Luganda.
So thank you very much, members of the Fourth Estate. You've walked with us this journey from when it began about 3 weeks ago to today. As I earlier highlighted by our colleague, Council CC, at exactly 12:30 this afternoon, we received the judgment in election petition number 1 of 2025, challenging the election of Honorable Nalukoola as the Member of Parliament for Kawempe North constituency. We would like to highlight that there were a number of allegations that were put forward by Hajat Nambi as far as this election was concerned. The total number of allegations were close to 27 allegations, ranging from different issues to do with bribery, obstruction of election officials, or obstruction of voters, campaigning, and disenfranchisement. And the court has annulled this election on 2 main grounds. The first ground is that the non-inclusion of the votes of 16,640 as the petitioner erroneously called them affected the results of the election in a substantial manner. Secondly, that Honorable Nalukoola campaigned at one of the polling stations in Kazo, Angola, and court, in its wisdom, found that this allegation had also been proved. So those are the only 2 grounds upon which the election and the will of the people of Kawempe North has been set aside by the Honorable Court. As officers of court, our number 1 obligation is to respect all court judgments, whether sensible or not, whether legal and compliant or not, or otherwise. Our duty is to respect. And we would like to say that as the legal team for Honorable Nalukoola, we respect the court judgment. However, we hasten to add that we fundamentally, we legally, we factually, and logically disagree with the judgment of court because it has defied all the known legal principles under the law. We've been saying it quite often, and we shall still continue to say it, that Uganda is a Commonwealth country, and we are bound by the doctrine of precedent. We are bound by the doctrine of stare decisis. And all courts are in hierarchy. So as a high court is bound by the decisions of the Supreme Court and the Court of Appeal. And we presented evidence to court on how it should treat the 14 polling stations in the absence of evidence from Honorable Nambi on who voted, how many people voted, how many votes were. Even in one of the cases of the Court of Appeal that were brought forward by the petitioner herself, that is Honorable Sarah Opendi Acheng, the Court of Appeal guided that when you're finding substantial effect, you do not subtract the total number of voters, because it's not true that all people could have voted. And the Court of Appeal said, don't do that when you are caught. The Supreme Court in Kizza Besigye had already said, don't do that. The Supreme Court in 2016 in Mbabazi said, don't do that. Even where we had over 2,000 polling stations in Kampala and the Greater Mukono not included, the Supreme Court said that cannot set aside an election. However, in the whole judgment we have seen of 56 pages, and we want to thank court that we finished the hearing on Wednesday in 2 days. It had read over 4,000 pages, over 5,000 pages. The court had analyzed all of the evidence we had been giving in 3 weeks, in 2 days, and it came out with a judgment on Monday.
They should keep up this precedent.
Of 56. We first of all want to thank court for such speed, supersonic speed, unprecedented in the history of our country. And we also encourage it to keep up this even in all the other cases that we're having. But we have not seen the reason why the judge has departed from the Supreme Court. We have not seen the reason why the judge has departed from the Court of Appeal guidance on how to deal with such a situation. Because it is very fundamental to note that the will of the people, the will of 92% of the people of Kawempe North, cannot just be turned around unless there are very justifiable legal grounds. And on that alone, we have instructions from both Honorable Nalukoola, who is away right now on his religious pilgrimage, and the party to challenge this finding of court, because it is against the law, it is against precedent, without justification for departure, but it also defeats logic, because there was no evidence to support that finding of court. We believe it is based on conjecture, and it is based on misapplication of the law. The other ground that we are challenging is the finding of court that Honorable Nalukoola campaigned at a polling station by saying amanyi g'abantu temugalya mulukwe, because that was the actual allegation. So that someone said amanyi g'abantu bagalya mulukwe, and it is the finding of court and the wisdom of court that that amounted to campaigning, that means Nalukoola. Vote Nalukoola. And that means people power. We want to say, one, that the court still, right from the Supreme Court, has been very emphatic that where partisan witnesses come to court and give evidence, you require some independent evidence to collaborate. All the people who came to give evidence on this matter clearly testified, both in their affidavits and the one they gave us to cross-examine, that they were agents and supporters of Nambi. So which other independent evidence did the court hear to make the finding? When you have one person, when you had so many other people on a polling station. But secondly, court in its wisdom found that the evidence of Kagumba, the evidence of Babide Sherina had not been rebutted. But you remember, since this hearing was public, We asked for these people to be cross-examined. Court refused. It gave us those it wanted us to cross-examine. So how do you now reach a judgment and you say that the other people you refused us to cross-examine were not rebutted? How would we rebut them when you, as court, had shielded them? So we believe these two areas that the court has based on to make a finding are legally flawed, and it's our obligation as members of the law to ensure that we go to the Superior Court to have a second eye on this. Finally, we have instructions still from our candidate that the people of Kawempe North who voted him are still willing to vote him, even more seriously. However, as a lawyer and as a person who believes in the rule of law, he must first exhaust the legal remedies to ensure that the law is put right. Because as we highlighted earlier, we are having very funny precedents in this country. We are having a lot of legal and judicial instability where you can't know how to advise a client because courts are making decisions that are very appealing legally. So he says, and he instructs us to immediately embark on an appeal to the Court of Appeal to make sure that we cure these legal anomalies.
Now, we are happy, of course, that this afternoon the High Court has agreed with us. It has agreed with Nambi. It has allowed her petition to declare Kawempe North election seat vacant. We premised our petition on a number of issues, but the court has agreed with two of them. The first one, which was our major ground, was that the number of people whose electoral choice we never got to know at the conclusion of this election was so great that it could affect the result of an election in a substantial manner. The court has agreed with us that 16,640,000 people were disenfranchised when the result of the election was not included in the final tally of the election. That was the first point. The second point the court has agreed with is campaigning on the day of the election. We told court that Nalukoola himself and through his agents campaigned for him on election day. The court has agreed with the evidence that we gave it and annulled the election on that second ground.
Certainly, and for the people that have been arguing that in the BCJ case, constitutional presidential petition 1 of 2001, 2006, John Patrick Amama Mbabazi case, Sarah Chengo Pendi case, court has always guided that those numbers could not be added onto the final tally and that they couldn't substantially change, and they've always gone as per that particular direction.
Yeah, I think there has been a misunderstanding by our colleagues and by the NUP team of this whole aspect. The first issue is that the BCJ Museveni decisions are decisions in a presidential election petition. Those decisions, as we told court, do not apply wholesomely on parliamentary election petitions. So that is a mistake. One of the mistakes they made was to think that the BCJ decision could be applied wholesomely to these parliamentary elections. That is incorrect. The judge has refused to do that, and we told them from word go that that was inapplicable. Second, whenever a margin is demonstrated to be higher, to be lower than the number of people whose electoral choice we do not know, the courts have all the time annulled the election. Okay? In all decisions that we gave the court, more than 10 of them, the Court of Appeal has annulled an election where it has been established that the margin is lower than the number of people whose electoral choice we do not know. And that was the case in this matter. The margin was only 8,000. The people who we do not know how they voted was double that margin. So the cases of BCJ, Sarah Ochengo Pendi, all those decisions did not apply because the situation was different from this case.
Are you happy that now people might use this as a pretext to any other election contender that can predict with certainty that they may certainly lose, to go and pick the boxes and certainly create that fear that maybe these numbers will not be included in the final tally and therefore be so sure that the election will be announced?
For us, we are happy that the court has set this precedent. Because if the court had not done so, the danger we would have fallen into would have been to allow the Electoral Commission to play around with the citizens' vote, fail to manage the election, fail to protect it, okay, in accordance with the law and its constitutional mandate, then come to the court and say that, sorry, my lord, we were unable to protect the vote, people came and kicked boxes, and please let the election be. That would be a bigger devil, that would be a bigger danger. So we told the court that should you green flag this kind of conduct in this election petition, you'll have destroyed elections in this country for generations. There was no way, we told the court, that the court can leave people kicking boxes, destroying electoral materials, and the court endorsing that kind of conduct. Said, no, don't endorse it. The Electoral Commission has a constitutional duty to protect and manage the elections so these occurrences do not happen again. Don't green flag it. If you do, you'll have destroyed elections. And the court agreed and says, no, the EC, don't come here when people kick boxes and tell me they kicked boxes and I failed to get results. You must get results. If, for example, 100 boxes had been kicked in this election, would the court have green flagged it? If 50 boxes had been kicked in this election, would the court have green flagged it? Is that the kind of democracy NUP wants? So there was no way we told the court that this election could be let to stand, because that would disorganize our democracy, that would diminish the constitutional mandate of the Electoral Commission, that would disorganize our elections forever. Well, it is their right to appeal against this decision. We have accomplished our job at the High Court level. The seat in Kawempe North is vacant. Nalukoola is no longer in Parliament. Appealing is his right. When they do, we shall handle them at that stage.
First of all, the Commission always respects court decisions. Secondly, as far as today's decision is concerned, this is a copy of the judgment. It's a 50-page judgment. I have not had occasion or opportunity to read it, internalize it, and understand the grounds on which the court premised itself to allow the election and what orders it gave in that regard. So I think in due course, after we have analyzed the judgment, we should be in position to determine as a commission the way forward. At this point in time, I think it is premature for us as a commission to contemplate holding a by-election in Kawempe on account of this decision. Why? Because under the law, they see the avenue process, the appellate process by any of the aggrieved parties. So it is only after that process has been concluded and the final court, which is the Court of Appeal, stroke Constitutional Court, has pronounced itself on the matter, that we can now determine whether we shall go for a by-election in the Kawempe North and when we should do that. So for the moment, I think, let us hold on and see whether the appeal process is concluded or any of the aggrieved parties in this petition is going to appeal to the Court of Appeal, and then we see the final decision. And secondly, the Commission can only begin the process of organizing for a by-election after receiving a formal notification from the Clerk to Parliament. That's what the Constitution says, that the Clerk to Parliament shall notify the Electoral Commission of the existence of a vacancy in Parliament, and the Electoral Commission shall conduct by-elections to fill that vacancy within 60 days. Since at the moment, two things have not yet happened. One, the days provided for in law for an appeal have not yet expired or lapsed. Secondly, we have not yet received any formal communication from the Clerk to Parliament notifying us of a vacancy in Parliament. Therefore, for us as a commission, we are still comfortably seated where we are. We cannot even contemplate or begin to plan for a by-election when the due processes in law have not yet been fully exhausted or complied with. Well, it depends on when we are required to begin that process of preparing for the by-election. I think that question can only be ably answered when we come to that period. Either is it in June Is it July? Is it August? Is it September? But now it would be premature for me to say whether we shall be in position to hold that by-election. It says that the law, the way we understand it as a commission, talks of polling day, because you cannot talk of the polling process takes place on a specific day. And the law has said that the Electoral Commission cannot set a day for polling or for voting unless and until nominations have been concluded for that particular elective office. So as we talk now, we cannot set the date for presidential elections, nor parliamentary elections or local government elections until after nominations have been done. However, you can do your own tabulation, because Article 61, Clause 2, is the benchmark, defines the timelines within which the general election must be held. It is within the first 30 days or the remaining 122 days to the expiry of the term of government. Now, when you look at if you do some simple tabulation, the term of government will lapse or expire on 12th of May 2006. So you count 122 days backwards. Okay? You get to about January 10th or 11th or 12th, around there. That's when those days begin from that time. Then you count the first 30 days going forward now of the 122 days. So that's why we say in our roadmap, if you recall, we say that polling for presidential, parliamentary, local government shall take place between 12th of January and 9th or 10th of February 2026. So now, if you count 6 months, therefore, from 12th January, you find you fall around 12th July 2026, and that's why 2025. So that's why we are saying at the moment, today is 20th of May. It will be very speculative for us to start talking of when we shall be, or whether we shall be able to hold that by-election if all the other due processes have been exhausted or complied with. It is very premature.
Okay, my lord, one would like to know, on several occasions courts have been setting orders and giving you orders as electoral commission,
yes,
on the way you should conduct the elections to avoid there will be circumstances,
yes,
of irregularity.
Petition, you will all recall, I think the main ground by the petitioner, that is Nambi, was that the failure by the commission to declare or announce the results from the 14 polling stations, okay, disadvantaged her. That probably if those results had been declared, she could have won. That was her case, all right? And we did concede and accept that indeed we could not declare the results from those 14 polling stations because some people came and destroyed the results after counting. And that was not the fault of the Electoral Commission. For us, we organized everything in accordance with the law. We expected the other stakeholders also to act in accordance with the law, and therefore we're not in position to declare those results. That the court seems to have found that, look, as far as you do not declare those results, therefore, you do not comply with the law. And therefore, we are saying, okay, we respect that court decision for now. We are going to study the judgment and see the grounds on which the court based itself, and then we determine the way forward. But for now, we are saying the Electoral Commission acts in accordance with the law, performs its tasks and duties. We expect all other stakeholders to do the same. The Commission did what in the circumstances was plausible or best. It did what it could do. First of all, we did not anticipate that any right-thinking member of society would go and attack the polling stations and destroy those materials or destroy those ballots or the counted results. We never expected that, because we expected whoever was participating in that process was sane and acting within the law. We never anticipated that. And secondly, the returning officer, having weighed the circumstances then, I think took the decision in his view that, look, we proceed to count the results from the 184 something polling stations. We leave out the 14 polling stations, and then so that we do not disenfranchise the voters from the other 184 polling stations. But the court seems to have been of a different view, which, as I said, we are going to analyze and see how it contextualized the reasons, the grounds, the reasons that resulted in the returning officer not being in position to declare or to tally and declare those results in the context of all the circumstances that prevailed on that day.
Yeah,
we want to start at that.
You're financially constrained. If a by-election happens, do you still have funds to organize it?
Again, that is speculative, because, as I said, we are not yet at the level of determining whether we shall be able to hold those elections until the due processes have been exhausted. There is an avenue for appeal, and that appeal can take place. The person who wishes to appeal has, I think, about 30 days from the date of judgment to lodge that appeal. That is one. Secondly, we still have, we cannot contemplate, or we cannot think or plan that we are going to have a by-election in Kawempe North, because we have to await the clerk to Parliament to formally notify the Commission that there is a vacancy in the Parliament. But as we talk now, I think Nalukoola is still in Parliament, despite the court decision. Until the clerk to Parliament notifies the Commission there is a vacancy in Kawempe North, and then we shall, the provisions of the Constitution under Article 81 shall be brought into play, that we must hold a by-election within 60 days. So for now, we are only guessing.